If you own real estate in California, you have to have some type of estate plan. As an estate planning attorney, we see this every day in probate court. Someone fails to have an estate plan in place that includes a revocable living trust, and their assets are then pushed into probate court, especially if they own a home, because the value of the home is going to ensure that they have to go through probate. The way that we avoid having to go through probate court when somebody owns real property in California is by having a trust. Having a trust allows them to own that property as the trustee of their trust, and that property would then be titled in the name of their trust. So if something were to happen to them, those assets would avoid having to go through probate court and just be able to be distributed according to their trust plan. It is important when you are doing your estate plan, when you own property in California, to ensure that you are minimizing the tax implications when it comes to reassessment of property transfers. When it comes to Prop 13 and our new Prop 19 requirements, it is important to understand the requirements when it comes to having that property as your primary residence and then transferring it to a child of yours or grandchild, assuming that you have met that requirement, and then making sure that you have an exemption that's going to be filed called a parent-child exemption to ensure that those property tax rates are then transferred to the child. One of the things that I see that people try to do to avoid having to go through probate court is by adding their child onto title of their property. I do not recommend that you do this without talking with an attorney first. There are several things that can come up that people don't think through when they just add their child to the property deed. Some of those things can include creditors. What if your child has bills? What if they get in a car accident and they don't have enough insurance to cover the damage that is done? They can personally come after your home if your child is on title to that property. Another issue that could happen is the assessor could have a reassessment on your property. And in the meantime, you have to pay those high property taxes of that reassessment while you continue to fight with the assessor's office on trying to get the reduction. Another issue with adding your child to title is not understanding how title is actually held and what ramifications that will be for if you have any other children that may be inheriting. Because if you add one child as joint owner of your home and you have other children that you would want to inherit, that child would receive upon your passing. And there is nothing in writing that says that they have to share in that house with the other children. So it's important to ensure that by having a trust, having your house in the name of your trust, then it can be distributed according to your wishes, where it would be one child that would just own that property in their name. A final consideration which can have the biggest tax effect is a step up in basis. When you add a child to title of that property, they get no step up in basis at your passing. And what that means is that when you pass away and your child were to inherit the property, let's say through the trust, at your passing, whatever the value of the home is at the time of your passing, from the time that you bought that property, the value is then stepped up to that date of death value so that when your child goes to sell the property, they would not have to pay capital gains taxes on the difference in the cost. Whereas if you just add them to title and they were then to inherit it because of joint ownership, then when they go to sell the property, they would have to pay capital gains taxes for that entire amount from the time it was purchased. If you own multiple homes, maybe have rental property, an estate plan can be created and designed to ensure that there's going to be protections in place to make sure that you are protected, whether it's maybe creating an LLC or some type of business entity to have those protections in place. But it's also there to ensure that however you want those assets distributed are there according to the terms of your trust. And you get to design your plan, which would then avoid probate court. If you own a property in California and you are looking to put a plan in place to make sure that your assets are going to be protected and that your family is protected, please call us here at Hermance Law. We are ready to work with you.